Representative Scott moves House File 54, and I know that you've had some conversations. We will discuss those conversations throughout the course of this hearing, Representative Scott, but at least as it stands now, the referral is to the General Register. Is that correct?
That's correct, Mr.
Okay.
Chair. Thank you. Mr. Chair and members, thank you. This bill originated from, it was brought to me by Chris Busey. And Chris, Mr. Busey used to run Minute. He used to be the CISO over there. And he's now with the Legislative Auditor's Office. And he brought this issue to me back, I believe it was in October or November. And we met on this issue, and basically his concern was that he had, even when he was at Minute, he operated under the assumption that if there's a data breach, regardless of the reason or the intent, that the people whose data was breached should be notified. And I believe it was the Office of Data Practices that brought it to his attention that there's actually two requirements before it can be classified as a data breach in current statute. One is that there's an unauthorized acquisition of the data, and the second, that there's intent to use the data for an unauthorized purpose. And we all hear almost daily about data breaches, and certainly if we're, whether we're one of the people whose data was breached or not, we certainly sympathize with the people whose data was breached, and we feel, I think probably everyone around this table believes that those people ought to be notified that their data was put at risk. And so what we did was we just removed the intent piece as being a requirement under current statute that would constitute a data breach. So this bill, we took it through the Minnesota, or the Legislative Data Practices Commission, and it received overwhelming support to bring this to the full legislature, and that's why I introduced the bill this year. As is custom around here, we posted the Representative or Chair Lesh and his staff posted the bill that was going to be heard. I believe that was posted the end of last week, so it's been out there in the public domain for quite some time. And yesterday afternoon, I received a couple of inquiries and some possible issues with the bill going forward. So I'm sure those people are here today. They probably want to speak on the issues that they have with the bill. So when the chair opens it up for those folks to come forward, you'll hear what their concerns are. I also want to say that the League of Minnesota Cities and the Minnesota Association of Counties were in my office last week, and they told me then that they would be neutral on this bill. So with that, Mr. Chair, I will open up for questions from members or however you want to handle it.
Thank you, Chair Scott. Now, I don't see Mr. Webster here, but is there anyone else who would be here to testify in support? Raise your hand if you're here to testify in support of the bill. Okay, folks just kind of saw it. Can you, well, maybe I could have research go into a little more depth about what we're trying to prevent. Members, you have in your packet a letter from Mr. Webster dated January 23rd regarding the disclosure of data, which he then redacted by the Duluth Police Department. And unless you're a Chapter 13 data practices nerd, it's a little complicated. So I'm wondering if research can just kind of give us a lowdown of what we're trying to prevent here. Mr. Hopkins.
Mr. Chair and members, under current law, this is section 13.055 in the Data Practices Act. This section prescribes when a government entity has to give notification for people whose private or confidential data was subject to a breach in the security of the data. The issue addressed by House File 54 is how a government entity determines when there has been a data breach. Under current law, there's been a breach in the data which triggers these notice procedures if a person views or takes private or confidential data without permission or statutory authority, and this is the important element for purposes of House File 54, that person has to have the intent to use the private or confidential data for non-governmental purposes. What House File 54 does is eliminate that intent requirement. So a government entity wouldn't have to know the intent of the person who views or takes private or confidential data in order to determine whether or not there's a breach. A breach would occur simply if a person viewed or took private or confidential data without permission or statutory authority.
Thank you. Chair Johnson.
Chair Lesh, I'm wondering if in a little more layman's term it would be if somebody's sending out an email and it unintentionally attaches a file with a whole bunch of private data to somebody. That would constitute a breach. When the person's information was inadvertently sent out, they'd have to be notified.
I think that's fair characterization, but Mr. Hopkins, do you want to speak to that?
Mr. Chair, under current law, in order for there to be a breach of the data, the person receiving that inadvertently addressed email would have to have an intent to use the data for non-governmental purposes. This bill would eliminate that requirement.
Thank you. Okay, other questions before Chair Liebling?
Thank you, Mr. Chair. And just for House research, so just as I'm understanding this, this is only being changed for purposes of when notification must be made. Is that right? It doesn't change, when you just look at it sort of in isolation here, the way the bill is, because we don't have the whole section, just the, we don't have here in the bill what section 13.055, all of it is, right? So am I right about that, that it only would change it for purposes of putting more of a duty on government, if you will, we'd be sending out more notices, but that's the only change that would really happen?
Mr. Chair, Representative Liebling and members, yes, that's correct. The 13.055 sets forth notice procedures that a government entity has to go through when there's been a breach in the data. So by changing the definition of what a breach in the data, breach in security of the data is, the law changes when a government entity has to go through those notice procedures.
Thank you.
Chair Considine.
I'm sorry. Sorry, Mr. Chair, I was just kind of scratching my head.
Got it. Okay. Well, I noticed when you scratch your head, Chair Considine. Okay. There being no other questions now for the author, are there members of the public who want to come up and speak to this? Okay, Ms. Byer-Krupinski is here. Okay. And then Hennepin County be ready to come down after that. Ms. Byer-Krupinski, welcome back.
Good morning, Mr. Chair and members. I'm Lori Byer-Krupinski with the Department of Administration. I wanted to let the committee know, as Chair Scott has mentioned, that yesterday the Governor's Office and Minnesota Management and Budget reached out to get some technical expertise as well as some legislative drafting assistance from Admin's Data Practices Office, your subject matter expert. They've identified issues that uniquely impact state agencies that they have discussed with Chair Scott. Admin really appreciates the opportunity to work with them as well as the author to develop some possible amendment language. The executive branch agrees with the goals of the bill to ensure that individuals are notified when their data has been released when it poses a risk to them. State agencies are just looking to clarify when those notices are required. And I can stand for any questions you might have.
Any questions for Ms. Byer-Krupinski? Okay. There being none now, Ms. Byer-Krupinski, can you stick around? Because there might be some questions for the other folks to come up, testify on it.
Mr. Chair, members, of course.
Okay, thank you. Appreciate it. We've got Christine Lottie Johnson, and I'm sorry if I butchered your name, Hennepin County Data Compliance Officer. Welcome. Please introduce yourself.
Thank you. My name is Christy Lottie Johnson, and I'm the Responsible Authority and Data Compliance Official for Hennepin County. And as Ms. Byers-Kempinski mentioned, we aren't necessarily opposed to the language, but we think that the language as it's proposed, we need to be able, counties and government entities need to be able to complete a risk analysis prior to notifying individuals to determine whether or not notification would be appropriate. I do have a couple of examples where Hennepin County was the subject of some phishing attempts, and we needed to send out notices to people who were on a spreadsheet. The spreadsheet had the first name, last initial, and the name of the account number of a department that would be charged for interpreter services. And in that case, we had to send out notices to people because of how private data is defined in the Data Practices Act. In the Data Practices Act, just the fact that a person's name and the fact that they are receiving some type of human services, that is considered private data. But when we sent out the notices, what we got back was a lot of anxiety from people. What does this mean for me? Am I at financial risk? And the answer was no, you're not at financial risk. Somebody knows that you received services, maybe somebody knows that you received services for Spanish interpretation. And that was it. And so part of what we want to do is we want to make sure that when we notify people, we're striking a balance and taking care to not raise anxiety further than what it needs to be raised.
Any questions for Ms. Lottie Johnson? Okay. Ms. Lottie Johnson, can I ask you, when did you receive notice that this bill was going to be up before this committee?
2 days ago, maybe?
Okay. Well, and I'm not going to pile on here. You're a government official who's come forward to testify, but I would just reiterate what Chair Scott said, that this wound its way through the Data Practices Commission, and it's been noticed for a couple weeks. And I think Chair Scott just found out about a lot of concerns in the last 48 hours, which I think would be frustrating to me. Was it 48 hours?
Less than 24.
Okay, less than 24. And I would also state, Ms. Lottie Johnson, that for good or for ill, your concern about anxiety of people when they receive a notice really is the purview of this committee, not really yours. Not to put it a little too bluntly, but if the effects of the policy we make is having that impact, that's something that we're accountable for, because we have chosen to make a broad, categorization in favor of protecting folks, which sometimes does have that bad effect.
Correct.
But I guess I would just state that that's the purview and decision-making that we got to decide here.
Correct.
So it's not something that you're really in the position of having to do, because you just got to follow the law. Representative Carlson.
Thank you, Mr. Chair. Question to the testifier. You mentioned that there was like an evaluation, some steps that had to be taken in terms of this decision-making process. Could you spend a few minutes just elaborating on that a little bit for us, please?
Well,
Ms.
at
Lottie
this,
Johnson.
thank you, Chair. Representative, at this point, we have the analysis that's in front of us around the intent. And if there is the intent, at this point, we do that. What we've been thinking about and looking at is an analysis around the risk to the individual, and whether there are ways that we can do an analysis that would be available for someone if they would like to audit it or look at it. But if we could do an analysis to determine what the level of risk is, similar to what 325E.61 has in our statute, which is around the private industry and how they need to notice. And they need to notice if there's risk related to social security numbers, driver's license information, and bank account information in conjunction with a name of an individual. In those cases, Hennepin County has gone above and beyond what is required by statute. When we have situations when we've or inadvertently and released information, or someone has had access to information such as social security number, driver's license, bank account, along with a name, we not only notice, but we also offer identity protection, which is not required under statute. But we believe that it's the right thing to do to protect people as it relates to financial risk and identity theft.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Carlson. Ms. Lottie Johnson, are you in charge of kind of the data compliance for the whole county, including the sheriff's department and the county attorney as well?
Mr. Chair, no, I'm not. Thank you. The way it is set up is that every elected official is their own responsible authority, and then government entities are also required to have a responsible authority. So I am the responsible authority for Hennepin County non-elected, and then the county attorney is his own responsible authority, the sheriff is his own responsible authority, and then also within statute, the welfare director is his or her own responsible authority.
Understood. Okay, thank you. Well, I know that members of this committee have expressed dissatisfaction with Mr. Webster's attempt to get information out of those other entities, so I had to ask, but thank you for the answer. Chair Liebling.
Thanks, Mr. Chair. I just, I want to make sure I'm understanding what you're saying, because, I mean, this is obviously really important. But, so the language in the bill that Chair Scott is trying to delete here, it sounds to me like you have issues, and I think your concerns are all valid, you know. I mean, I think we all, notwithstanding kind of the chair sort of taking that concern off of you, I think it's just normal for all of us to worry about, you know, where is the proper balance. But with the language in current law, are you sort of looking at that language as allowing a kind of a risk assessment in your decision-making? That's what I'm kind of struggling with a little bit. The part about how is private data defined, that's not on the table today. That's elsewhere in law, and if there's a concern about that, then we have to look at that. But this issue with intent, it seems to me that, you know, is the concern that, you know, when you've got this intent piece and you can say, well, there wasn't any intent, so it's not really that much of a risk, therefore we're not required to notify people, and we can kind of make more of that balance ourselves? Is that kind of how you're looking at that current language?
Ms. Lyda Johnson.
Representative, Mr. Chair. No, that's not the way we're doing that right now. Right now, if it's private data, we notify. What we would like to do is we would like to propose some language around a risk analysis. And actually, as part of the risk analysis, we're not looking at the intent of the recipient. We have some other language that we would like to consider besides the intent.
So, Mr.
Okay.
Chair.
Yeah, Chair
Yeah,
Liebling.
thank you for that. And, you know, I think I can't speak for anyone else, but I think that it's probably appropriate to have some sort of risk analysis in there. But I'm not sure that this language that Chair Scott is trying to delete is giving us that. So anyway, I just wanted to make sure I was clear, because I know you kind of went into a few other areas that are obviously related, but not the same thing. So
Right.
thank you.
Okay, Chair Considine.
Thank you, Mr. Chair. Chair Scott, given that you have found these concerns raised in the last 24 hours, is there something in there that might cause you to want to pause, reevaluate, since you didn't know about it until recently?
Chair Scott.
Thank you, Chair Considine, and thank you, Chair Lesh. I think what Chair Liebling has uncovered here is that the issue may not necessarily be with this bill. This is simply taking intent away. They're already notifying people with the language the way it currently is. So there's a two-step process right now, or two reasons, two criteria that have to be met before they are required by current law to notify someone that their data has been breached. And even though the intent may not have been ill intent in the example that they gave, they still notified people. So they're already interpreting the law much like probably most agencies already are around the state and government entities. And why Mr. Busey brought this forward was that most government is already operating under the assumption that anytime anyone's data is breached, the person should be notified, regardless of intent. Because very much, there's a lot of innocent, you know, comings and goings of email and releases of data, and we know that there's not always ill intent. But most agencies and government entities are erring on the side of caution already. So I think we're actually talking about two separate issues here, long and short of it. Am I willing to work on this? Sure. But I'm just not sure that their concerns pertain to this specific bill language. If that makes sense.
Thank you. Yeah, Chair Johnson?
Thank you.
Okay. Representative Carlson?
Thank you, Mr. Chair. What's the next stop for this bill?
It's going to the floor, Representative Carlson.
Okay, Mr. Chair, based on the author's comment about willing to continue to work on the bill, is there a reason to take a pause and have this be further looked at and allow for others that have expertise and experience in dealing with these types of issues to take a closer look at this? It seems like it's being rushed. I guess there's a question. Is there an opportunity to table this to allow for further conversation with other subject matter experts?
Well, Representative Carlson, I'm going to leave that up to the author. I think having wound its way through the Data Practices Commission, this having been talked about for a year, that I don't think it's being rushed. However, I do get the sense that Chair Scott is willing to work with folks who have concerns on this. It probably is my intent, if it's amenable to Chair Scott, to bring this back in a week and give folks with concerns a week to really put forth proposed language that will pass muster with Chair Scott. But I'm going to leave that up to you as the author, Chair Scott. What do you think?
Yep, that's fine, Chair Lesh, and I'm glad to work with people if, but what I'm concerned about is there may be a separate bill here that's not even, is what they're addressing. So,
Okay.
but we can discuss that when we meet.
All right.
Glad to do that.
Thank you. Then that's what we'll do. But you know what? I shouldn't have said that because I want other folks to step down and state concerns first. Don't take my blurting out, hey, maybe we'll hold off on this to be any indication that you got extra time to talk about this, because you really don't. So if there are other folks that want to put on the record their concerns about the bill, that's what this hearing is for. So come down right now and put them on the record, okay? No one wants to come down. Okay. Chair Johnson?
Chair Lesh, I look at this bill and I read it. I've seen some of the news reports of what's happened lately over, even at the state level and sometimes at the city levels, where emails are inadvertently sent out attached with information. There was no intent. By our current law, because there was no intent, no notification has to be given out that your personal data was released. That's wrong. I want to thank Representative Scott for bringing this forward. The Data Commission has worked very hard on it. I would just as soon just move forward this bill, get it to the floor, because anytime, especially the state, inadvertently relieves private personal data, the people whose data was released should be notified immediately.
Thank you for that statement, Chair Johnson. I would note that the only concerns, even, tepid concerns as they've been characterized, I shouldn't say that, that sounds pejorative, but nominal concerns as stated by Ms. Lottie Johnson are the only ones that have been stated on the record. So I don't know what else Chair Scott is supposed to work with in terms of crafting any comfort language between now and a week from now, but I really would hope that any of y'all that have additional concerns, that you would bring them to her today, written out, not just an oral, hey, you should really do this, but written out in the form of proposed language change. That's the only way it's going to be helpful to her and to this committee. So with that, we will, Chair lays it over for a week. Thank you very much.
Thank you, members.
Chair Scott.